This courtroom hearing starts like any other, but within seconds, it explodes into pure chaos. A woman known online as Karen, identified in court as Miss Stevenson, appears before the judge over a bankruptcy and eviction case, but instead of calmly explaining her situation, she immediately goes on the offensive. Interrupting. Arguing. Refusing to directly answer questions. The tension builds fast. The court reveals she previously filed for Chapter 13 bankruptcy back in November 2022. But that case was dismissed after she failed to make payments. In fact, records show a 0% payment history. On top of that, she hasn't paid rent since September 2021, racking up more than $12,000 in unpaid balance. But just when it looks like the eviction might move forward, she drops a new claim. She says she filed another bankruptcy. The judge asks for proof, a case number, confirmation, anything official. After reviewing the system, the court finds what's called a skeletal petition, a bare minimum bankruptcy filing that temporarily pauses proceedings but requires full paperwork within 14 days. Here's where it gets intense. Miss Stevenson continues interrupting, accusing the court of silencing her, even as the judge tries to maintain order. At one point, she's muted because of constant disruptions. The judge remains calm, sticks to procedure, and explains that the automatic stay from this new filing only lasts 30 days due to her prior dismissal. Instead of ending the matter, the judge reschedules the hearing for a later date to verify whether the bankruptcy will actually move forward. And in a final dramatic moment, she declares she won't even show up, but the judge makes it clear, the hearing will proceed with or without her. Was this a genuine attempt to protect her rights? Or a calculated delay strategy? Watch until the end, because this courtroom showdown is one you have to see to believe.
Marquia Stevenson.
Okay, thank you. And so, Ms. Lugoff, this is the date scheduled. Okay, so there was a bankruptcy stay that was entered November of 2022. And then there was an order reopening the case after bankruptcy. And so this is the hearing for that. And so, counsel, you had an opportunity to speak to Ms. Stevenson in the breakout room, correct?
Yes, Your Honor, and I'd like to create a record right now. So the defendant had her initial hearing on November 4th, and she filed a bankruptcy right before that hearing. She did appear, she was given her rights. Her bankruptcy, she had filed a Chapter 13. It was dismissed for failure to comply. She paid zero into her plan. She has not paid herself. She has not paid the landlord rent since September of 2021. Since that time, she had Sarah payments. She has a balance right now of $12,106, Your Honor. She informed me in the breakout room she's filed another bankruptcy. I don't have any notice of this bankruptcy. There's no bankruptcy attorney here, but that is what she is asserting. We are going to be objecting to any discharge because if she filed it right before this hearing again. And there clearly seems to be some abuse here, but she can provide the case number for the court. And, if a stay needs to be in place, then a stay needs to be in place. But I have no knowledge personally of any bankruptcy, and my client has not received a notice of bankruptcy proceedings.
Okay, Ms. Stevenson, please raise your right hand.
Yes, Your Honor.
Do you solemnly swear or affirm the testimony about
I've been filed bankruptcy.
Ms. Stevenson, please raise your right hand. Is your right hand raised? I can't see.
Yes, ma'am.
Okay, do you solemnly swear or affirm the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. Okay, and so, Ms. Stevenson, I'm not sure about your connection. It seems to be a little bit spotty. Okay, so initially you filed bankruptcy in November of 2023, correct?
Yes.
And then that was chapter 13, is that correct?
Yes.
And you were ordered to make payments within that bankruptcy case, correct?
Incorrect.
That's incorrect?
Yes, ma'am.
Okay. So chapter 13, were you required to make any payments at all?
I fired my lawyer for the chapter 13. I reached out to Royal Woods because the payment plan that he came up with, I did not agree with. So I fired him. I contacted Royal Woods and I told them about my new attorney. And I just gave Miss Lockoff the case number.
I don't have the case number. Her connection was spotty. She said 23. That's all I have, Your Honor.
Okay.
I can give you the case number, Your Honor.
What is the case number?
Okay, 1 second, please. My case number is 23-44007.
When was that case filed?
It actually, I contacted them in January, and my lawyer told me to contact him when I received the court papers for eviction or a hearing. So I contacted him, and he filed the case last week. And I did contact Royal Woods as well.
Who did you speak to?
I spoke to Andrew at Royal Woods, and I informed him, and also a lady named Cheryl at the office, at the the corporate office. She emailed me and actually called me. I told her, I said, I have another case and I don't know why we're going to court. I still need the 30 days, to vacate the premises. She said, okay, we're still going to take you to court. I said, okay, fine. I said, you guys are wasting your time because I'm on another automatic stay.
She's a professional. Your Honor.
So are you
respectfully,
I'm
just
just one moment, Ms. Luckoff.
Yeah.
So are you planning on relocating then, Ms. Stevenson?
Ma'am?
Yes. Are you planning on relocating then?
Could you repeat that, Your Honor?
Are you planning on relocating?
At my leisure.
At your leisure.
my
That's not
time.
how that works, ma'am. On your own time. That isn't how this works.
Yes, ma'am. See, a bankruptcy.
I'm sorry, your connection is not very good. What did you say after bankruptcy?
I don't even supposed to be here, Your Honor, and I don't even supposed to be here.
Why not?
This is not bankruptcy court. This is not bankruptcy court. I don't even have to explain myself.
Ma'am?
I have right. I have right.
Well,
I don't supposed to be here, Your Honor. You are not a bankruptcy judge. You are not a bankruptcy judge.
You are absolutely correct. I am a district court judge and I have jurisdiction over this matter because we do not have anything in our files or anything that was filed by you or any attorney representing you that would support your claim that you have filed another bankruptcy case.
I gave you guys the case number on record, so you guys can try me if you want to.
Ma'am, where is the documentation regarding your case? You should have some paperwork. Please stop interrupting me.
I will email it to Ms. Lockoff right now.
Please stop interrupting me. You can email it to the court at 27dc@yn.mi.gov.
1 second. Do you want me to do it now? Because I will do it now.
Yes, ma'am. We're going to take a brief recess. We're going to go off the record so you can submit that.
What starts as a routine bankruptcy hearing slowly turns into one of the most tense and chaotic courtroom exchanges you'll ever see. The judge calls the case, expecting a standard update connected to an eviction proceeding. Instead, from the very first response, the tone shifts. Miss Stevenson appears on the virtual screen already defensive, already frustrated, already prepared for a fight. Before the court can even fully explain the purpose of the hearing, she begins interrupting, talking over the judge, challenging the process itself.
The court attempts to establish the record calmly and clearly. This is not her first bankruptcy filing. Back in November 2022, she filed for Chapter 13 protection. That case, however, did not succeed. It was dismissed. The reason was straightforward: failure to comply with the repayment plan. According to the payment history presented, none of the required payments were made. 0% completion. At the same time, rent had reportedly not been paid since September 2021, resulting in a balance exceeding $12,000. Those numbers immediately set the foundation for why the eviction matter is even before the court. But instead of acknowledging that history, Ms. Stevenson resists it. She insists there is more to the story. She suggests she has taken new action, that the situation has changed. She claims she has filed another bankruptcy case. The judge pauses and asks the most basic question any court would ask: what is the case number? If a new bankruptcy has been filed, there should be confirmation. There should be documentation. There's a delay. There's hesitation. The court system is checked. Eventually, a new filing does appear in the records. But it's not a fully completed bankruptcy petition. It's what's known as a skeletal petition. That means only the bare minimum documents were submitted, just enough to open the case and temporarily trigger the automatic stay. The automatic stay is powerful. It can halt eviction proceedings immediately. But it is not unconditional. It comes with strict deadlines. Within 14 days, the filer must submit all required schedules, financial disclosures, and documentation. If that paperwork is not completed properly, the case can be dismissed just as quickly as it was filed. The judge explains this carefully, methodically, without emotion. There is another critical factor. Because her previous bankruptcy was dismissed within the past year, the automatic stay in this new case is limited. It will only remain in effect for 30 days unless she files a motion and convinces the court to extend it. That means the protection is temporary. It is not a long-term shield. It is a narrow window. As the explanation continues, the interruptions increase. Ms. Stevenson speaks over the judge repeatedly. She accuses the court of not letting her speak while actively interrupting. The audio becomes chaotic. The judge attempts to regain control of the hearing, reminding her to wait her turn, reminding her that court proceedings require order. Instead of de-escalating, the tension rises. Her frustration is visible. Her tone sharpens. The courtroom dynamic shifts from procedural to confrontational. At one point, because of the constant interruptions and poor audio connection, the judge mutes her microphone in order to continue explaining the legal posture of the case. Even muted, she continues gesturing, visibly upset. The judge remains composed. There is no shouting from the bench. No sarcasm. Just steady repetition of the legal framework. The court makes it clear that filing a skeletal petition does not automatically solve the underlying issues. Bankruptcy law is structured to provide relief to those who follow through with the process. It requires transparency, documentation, and compliance. A filing alone is only the beginning. The court emphasizes that if the required documents are not submitted within 14 days, the bankruptcy trustee can move to dismiss the case. If that happens, the limited automatic stay protection will vanish. Meanwhile, the eviction matter cannot simply be ignored. The Landlord's Council outlines the history of unpaid rent, the prior dismissal, and the financial impact. From their perspective, this is not a sudden hardship. It is an extended period of non-payment spanning years. That context shapes the court's careful handling of the situation. The judge must balance the legal protections available under bankruptcy law with the rights of the property owner seeking relief. Ms. Stevenson continues to argue that she is being treated unfairly. She insists she has rights. She suggests the system is not giving her a fair opportunity to explain herself. The judge responds by pointing out that she is being given the opportunity, but that opportunity must occur within structured procedure. Courts operate on rules, deadlines, and documentation. Emotional arguments cannot replace required filings. As the hearing progresses, it becomes clear that the immediate question is not whether she feels wronged, but whether the new bankruptcy filing will be properly completed. Without full documentation, the skeletal petition is temporary at best. The judge decides that the most appropriate course of action is to reschedule the hearing. The new date is set after the 14-day deadline expires. That timing is intentional. It allows the court to verify whether the bankruptcy case remains active or has been dismissed again. The judge explains that by the time of the next hearing, one of two things will be true. Either she will have completed her filings and the bankruptcy will proceed, or the case will have been dismissed for failure to comply. That clarity is necessary before the eviction matter can move forward appropriately. Then comes one of the most striking moments of the hearing. Ms. Stevenson states that she will not attend the next court date. Whether said out of frustration or defiance, the statement hangs in the air. The judge responds calmly and firmly, the hearing will proceed with or without her presence. Court dates are not optional simply because someone is unhappy with the process. That statement underscores the broader theme of the entire exchange. The courtroom is not a debate stage. It is a procedural environment governed by rules. The judge's role is not to argue but to apply the law consistently. Even in the face of hostility, the bench remains measured. As the session winds down, the tension does not fully disappear. The underlying issues remain unresolved. A dismissed bankruptcy in the past. Years of unpaid rent. A newly filed skeletal petition with strict deadlines. A limited automatic stay that expires quickly unless extended. All of these legal realities form a narrow path forward. What makes the hearing so intense is not just the legal technicalities, but the emotional collision between procedure and frustration. Bankruptcy law can offer powerful protection. But it is not automatic immunity. It requires participation. It requires follow-through. It requires compliance with deadlines and full disclosure of financial circumstances. In the end, the next chapter of this case will depend entirely on whether those requirements are met. If the paperwork is completed within 14 days and a motion to extend the stay is filed successfully, the case could continue under bankruptcy protection. If not, the dismissal could clear the path for eviction proceedings to resume. What began as a routine docket call transformed into a vivid demonstration of how the legal system responds under pressure. Calm authority on one side, open defiance on the other, and somewhere in between, the rigid structure of bankruptcy law dictating what happens next. The final outcome is not decided in heated words or interruptions. It will be decided in paperwork, deadlines, and compliance. And that is where this courtroom drama ultimately leads, not to a shouting match, but to the quiet power of procedure.
Want me to do?
I just wanted to be able to see you, that's all, I can see you now. So I did receive your email regarding the communications from Fairmax Law. So I'm going to forward that to, reporting that to Ms. Luckoff. And then Ms. Luckoff is accessing your previous case so that she can send a copy of the register of actions to the court so I can review that. So, because this appears as though there is a skeletal bankruptcy petition and you still have 14 days before your case is actually filed or dismissed. So it doesn't appear as though there's a bankruptcy case at this point that would require this court to issue a stay, to comply with a stay, nor has there been a stay presented to this court.
I don't know what y'all talking about, but I don't mean to
I'm sorry,
interrupt
you're
you,
breaking up. I can't. You're breaking
Your
up,
Honor,
Ms. Stevenson.
but my case
Ms. Stevenson,
my
I
case
didn't hear, Ms. Stevenson, I'm not catching a lot of what you're saying because it's a bad connection. So I'm not catching everything you're saying. So can you please move locations? Okay, Ms. Stevenson? Can you please unmute?
I'm sorry about that. I'm here.
Okay,
Yeah.
hopefully you have better connection right now. Okay, so the court will note the, so I was just going through the procedural history, and based upon your 22 bankruptcy case, your case was dismissed March 6th of 2023, but the final decree and the closing of the case wasn't until April 25th of 2023. And it indicates that the order, the United States Bankruptcy Court, Eastern District of Michigan, Southern Division, Detroit, signed by Judge Maria Axel, the United States bankruptcy judge, indicates that the matter was scheduled for hearing on March 6th of 2023. And an oral motion to dismiss by the Chapter 13 trustee was not opposed by the debtors who were present or counsel represented them. It was dismissed for poor pay history, which was 0%. And therefore the case was dismissed and automatic stays issued were terminated. We'll also note that the documentation that was submitted by Ms. Stevenson to the court indicated that there was a skeletal bankruptcy petition that was filed. And Ms. Stevenson, what date was that skeletal bankruptcy petition filed? You're muted, just so you know you're muted. Please unmute. I'm sorry, what?
What are you talking about?
Well, your attorney on your 23 bankruptcy case filed a skeletal bankruptcy petition. What date was that filed?
It was filed completely. I don't know what that word means that you're
reading it from the I'm reading from the document that you sent to the court. Your attorney stated that they completed a bankruptcy analysis.
The document that I sent is,
excuse me. Please stop interrupting the court because we can't record more than one person at a time.
You're asking me a question. Let me ask.
Ms. Stevenson is no longer on here. She dropped off. The court did not remove her. I'm just making that a record right now. Ms. Stevenson, please unmute.
You guys would not let me say anything in this courtroom.
Just one moment. Just one moment. Your connection has not been good. And when you start answering a question, I'm not hearing everything you're saying, so I'm asking you to stop talking.
Okay, well, I'm talking right now. I am talking right now, Your Honor. I'm talking.
No, you're not talking. I just muted you. Now, please stop, because I see that you're still talking. You can continue to waste your breath. I muted you because your connection is poor. I cannot hear what you're saying because it's breaking up. So, have you moved to a new location? Have you moved to a location that you have better connection? Just so you know, I muted you, so you'll have to unmute.
I'm gonna type you in chat. Since you can't hear me, I'm gonna type you in chat.
I'm sorry, what is that?
I'm going to type you in chat.
Nope, we don't have chat enabled, ma'am. You cannot send a message via chat.
Well, I'm letting you know I'm not supposed to be here. My bankruptcy has been filed.
No, ma'am, that is
My
not accurate.
bankruptcy has been filed. You guys
Excuse me.
to the bankruptcy. If you do anything or try to give anything that is on my record, I don't care. It better not be on my record.
Excuse me. You need to calm down. Excuse me. You need to calm down, ma'am.
I'm supposed to be here. I'm an attorney. I'm supposed to be here.
Okay, Ms. Stevenson, excuse me. Well, the court you're muted, Ms. Stevenson, because we can't catch much of what you're saying. Ms. Stevenson, stop talking. Stop talking. We cannot get what you're saying on the record because you're screaming and you don't have a good connection. So stop talking, please. Stop talking. Stop talking.
You heard what
Stop.
I said.
I am not one of your children, ma'am, so you need to stop. You are speaking to a court. Respect for the court. So, as I was saying, Ms. Luckoff, there is not another case that Ms. Stevenson filed in 2022. The court will note that, actually, Ms. Luckoff, can you pull up the names, the bankruptcy court filing to see when this bankruptcy petition was filed, please?
This
See if it was
one?
before May 3rd? Yes.
Okay.
The case number is 23-44007.
Okay. Okay. This says date filed 4/30/2023. Oh, excuse me, 4/30, Your Honor, 4/30.
On a Sunday?
That's what it says. Let me just,
Okay.
I'm going to open the petition here. See what we have here. If that comports. Yes, it says 4/30/2023.
Okay. All right. So what the court will note, counsel, is since there was only one case filed in 2022, well, actually, I'm sorry. When you open up the case, does it show if there is any motion that was filed along with the petition?
Let me look here. Okay, so it says petition, statement of social security number. I won't read you the whole thing, but let's see, motion. No notice of missing documents. There's no, I do not see a motion, Your Honor.
Okay. So,
You guys mess with me if you want to. I'm letting you know this now. I'm letting you know this now.
I'm letting you know to stop interrupting the court or you will be held in contempt of court. Stop. 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 The court is going to state that the petition was filed on April 30th. So there's 14 days to file the balance of what needs to be filed, which puts it to May 14th. And so, counsel, because there was only one action filed in 2022, there is a 30-day automatic stay that was triggered. So I cannot enter a judgment stay, but what I will do is I'm only going to set this out for 2 weeks, well, less than 2 weeks, because I'm going shortly after the 14 days by which the balance of the documents need to be filed or the bankruptcy is dismissed. I'm not going out 30 days right now. So the 30th day would be on May 14th. We don't have a docket on May 19th because of the mandatory judicial conference. So, counsel, are you available on May 16th at 1:30 in the afternoon?
I will make myself available, Your Honor.
And we are doing this in person.
The only thing I need to confirm, give me 1 second, is I have an in-person, nope, that's on the 15th. Okay.
You guys can contact my lawyer.
Excuse me, Ms. Stevenson, your lawyer has not filed an appearance here at all. So
He will.
your lawyer doesn't have, excuse me, then that's fine. Then your attorney will know how to proceed. You need to be here in person on May 16th at 1:30 p.m.
Why?
Because the court is going after the 14 days. We're setting this after the 14 days to make sure if the bankruptcy case is still proceeding or if it's been dismissed. So that is why the court is setting for May 16th. Stop interrupting me. Stop interrupting me. May 16th at 1:30 p.m.
I will not be there.